As ABC said in their statement, they played the video 3 times. Council chose not to play the video that was aired on ABC that was stopped, sped up, slowed down, freeze framed, and had graphics on it. The one that they showed, I'll grant you, is not a lot different from the original VAM file. But there's another one that is a lot different. And if Your Honor has seen it on the internet, Your Honor will agree with that. As to the license itself, the license, as counsel pointed out, says the video is to be used in the case. To me, that says, like we're in here, dealing with the case.
Let me ask you this, and I've already crossed this bridge in my family, this issue in my own mind looking at these motions. Isn't that GE's argument? I mean, if they violated the license, isn't that, if they've got an agreement or paid GE to buy their license, and they've violated the license, isn't that GE's issue?
It is GE's issue.
I mean, it's not really CSX's issue whether they violated the license. I mean, arguably, I think, frankly, and this is a big issue in electronic discovery, and it's an issue that's being actively taken up right now by the Superior Court Uniform Rules Committee and the State Court Uniform Rules Committee about what format you have to produce electronic discovery in. There was a bill in the General Assembly last year in Georgia that didn't make it. You guys, I'm sure, were following it, maybe participated in it. But you know, once they, it seems to me that that issue, the license issue, is a plaintiff's firm versus GE issue. Now I know that it has a third-party impact on CSX because it takes more trained locomotives with you. But whether they violate the license itself is sort of not necessarily relevant to my decision in this case.
We bring that issue up only to show what actually happened here. I agree that GE has the standing to enjoin them or revoke the license or whatever. CSX does not have standing to do that. It's just as evidence of what happened here, that they violated the license. They actually gave the video to ABC. ABC then altered the video and played it to the national audience. What CSX?
What if ABC?
There were 2 trains that went by before the incident, train that hit the film crew, etc. There's actually 3 trains that went by before that. 2 of which went by after 3 o'clock. And as you've heard, there's video on each of those trains. Video has been produced for a train that went by at 2 o'clock. And Bob, if we can put up the chart. Video has been produced for a train that went by at 2 o'clock, which everybody knows that the film crew wasn't even out there at 2 o'clock. They didn't arrive until around 3 o'clock on February 20th. After the film crew arrives, a train Q03220 goes by at about 3:28. That video is, according to them, has been written over, although if you read the affidavit by the person named Dylan Harrison who they've submitted, he never says that he went back and actually looked for the video. He just says that because they're written over every 72 hours, it's gone. And I thought something that was very interesting that was mentioned that Mr. Jordan represented to the court, which is that these are downloaded onto a hard drive. Well, I've just gone through this in another case where you have data that's written onto a hard drive. It is not that easy to erase. Data on a hard drive stays there. Even if it's written over, it can be found. In fact, there is Microsoft has a DoD, Department of Defense, standard for how you actually erase data from a hard drive. And it is a complex, long process that takes days to do. So one thing is, now that we have a representation for the very first time from CSX that this is actually saved on a hard drive, we definitely want to know if it can be found in that hard drive, and we're willing to send in some computer forensics people who can help with that and find that video, and we think if it's on a hard drive, it will be there. So that's one issue that we just learned as I was sitting over here listening to Mr. Jordan make his representations to the court. There was another train that went by 8 minutes later, 3:36 p.m., and shows, and I'm going to show this to you in a second, Your Honor, a number of people along the side of the tracks. And then there's the 4:25 train, that's the incident train, and where you can actually see the crew that's on there. Now, the reason why this is important is because CSX has repeatedly said to the police, to investigators, and to the media that they have unequivocally denied permission for anybody to do that. Well, that is not the case. There is, and this will obviously come out in the trial at some point, there are a number of emails between CSX and parties trying to get permission there. And CSX is very open to the idea. That's the stance they take. It isn't until the morning of February 20th that they send an email saying, we can't support you. That's what the email says. It doesn't say, you're denied permission, you can't be there. It says, we cannot support you. That's all it says. So first we have CSX is saying, well, we told them they couldn't be out there. Well, that's not accurate. And that's what they've been saying in the media this whole time. And they have all of these emails showing that they know people are going to be out there shooting a film on February 20th. Then they have not one, but 2 trains that go by and show people right by the tracks. Now, there has been documents produced in this case, and we think there will be more, and we may have a few more motions to tell Your Honor. I apologize for that, but we want to make sure we get all the information. But we'll show that when CSX knows that there's people in their right-of-way close to the tracks, they have a procedure. And what that procedure is a couple of things. Let your trains know, slow them down, get on the horn, send your people out. There's an instance that happened about a year before this one, where when they saw 2 people next to the tracks, they called the local police, they called their CSX police, they called the CSX risk manager. They sent them all out there to learn that it was somebody doing a survey for the government and actually had permission to get out there. They did that. In this case, they had 2 trains that went by, saw people next to the tracks, and did nothing. And then when the incident train comes by, it goes through there at 57 miles per hour, never takes any steps to slow down before striking the film crew. It blows through there, and it's not until after it hits the film crew, after it crosses the bridge, that for the very first time, starts trying to slow down that train. I don't know why that'll obviously come out in discovery in this case. But one of the things that CSX has said in this case, and Bob, if you can pull up 8-17.
Yes, sir.
This is the answer. This is actually part of their answer, I'm sorry. Down at the bottom, paragraph 86, Bob. CSX admits that 2 train crews which passed over the Rainier property prior to the incident issuing this lawsuit observed unidentified persons in the general vicinity, but not on or immediately near its railroad tracks. So what they're saying is, yeah, we saw people in the area, but we didn't see anybody close to the railroad tracks. Well, now the videos from that train, because of their defense, because what they have put at issue, become incredibly important and incredibly relevant. I'm going to play for you, Your Honor, the video of the train that went by at 3:36. Bob, if you can pull up clip 6.
Yes, sir.
This is the video of the train that goes by at 3:36, so this is about 45 minutes before the incident train. Stand over there. And you can see the trestle in the background as they're approaching. Bob, can you pause it? Right here, Your Honor. There are people right there next to the track. Right here, there's people right next to the track. They are in the right of way. They're on the gravel. They are literally feet from the track. Go ahead and play it, Bob. So this isn't just general vicinity. This is right there next to the track. Go ahead and play it. So 3:36 p.m., we know that at least one train went by and saw people right next to the tracks. And as Mr. Jordan himself said, the purpose of this video is to show what the engineers and conductors saw. So because of their own admission, we know that the engineers and conductors saw people right next to the track. But there was a train that went by 8 minutes before that one. And that is crucial evidence in this case. And that was not preserved. That was lost. They say it was never identified, so they never downloaded it. Now we learn for the very first time that it was saved onto a hard drive, and we don't even know if they've ever actually looked. We know that they believe it's been overwritten. And another thing, just to be clear about, Your Honor, just if you look at the facts of this case and the facts of what happened on that day. So you've got the 2 trains that go by ahead of time. They see the people there, do nothing. And by the way, Your Honor, the other issue that hasn't been raised yet, but it's a connected issue, is that the dispatcher recordings, so the talk between the dispatcher and the train, those also do not exist for that train that went by 8 minutes before. And if you can put the chart back up.
Yes, sir.
So the dispatcher recordings for train Q03220 apparently are also missing. So that's a connected issue.
Is that in the motion to compel?
We did not put that in the motion to compel, Your Honor, and we were happy to file another one, but it's, from our view, it's a connected issue because it both has to do with whether or not they identified and downloaded that train.
Let me ask you, is the
Number 27, right? Yeah. So here's the question where we ask for, this is our request for production of documents, where we ask for any of the downloads, disc, or other form of memorialization from the locomotive recording devices active in the subject train at the time of the subject incident. They say that we have to download this, we have to get the software, and as Mr. Harris has already told you, we thought about, we know we don't have to go get that, but we wanted to just get the video. We wanted to start moving this case forward, so we went ahead and got that. They don't disclose it there. They then do a supplemental response. There's also, just for the record, Your Honor, in request number 32 and 34, we also asked for video and photos of trains that went by. And they, again, never disclosed it. And then in their supplemental response that they filed, Your Honor, 3-3, Bob? They again say, in 27, that they're going to send us the LDVR once we have proof we purchased it. Again, they never say anything about any missing records, any missing video. It isn't until we have a 6.4 conference that for the very first time they then say, oh, by the way, we didn't get the recordings of one of the trains that went by there, but it's not a big deal because it's only 8 minutes before, and everybody's going to testify that it looks exactly the same. Well, the problem is, Your Honor, is that the key point of this case, the key issue that's going to be in this case is how much notice did CSX have that there were going to be people in there. We think that the evidence is going to show that it was substantial notice, and that they knew immediately. They're out there working with the police. They're out there investigating what happened. They're out there the entire time. They know how to preserve evidence. They didn't do it, and they haven't even looked, according to their own affidavit. So the one thing we want, so we do not have a discovery response at this point saying that they've ever either lost, didn't download, overwrote, destroyed this video. We don't have anything in the record. All we have is what they've told us. So at the very minimum, we need to make sure that we have a statement from them that it is lost and cannot be found. But the second part of that is that now we know that it's potentially on a hard drive. We would ask for an order from Your Honor searching that hard drive with a forensic computer specialist, and we're happy to provide one that will search for and find that video, because unless they've done the DOD specification for how you delete stuff from a hard drive, it should be there. So that's one thing that we would ask as far as this video. The next issue, and I'm actually surprised that we're arguing this issue or making that argument. There is no case law to support that. They then try to say it's a work product, that somehow this is their work product, and that they don't have to produce it because of that. Well, these are scene photos. This is the scene, this is the photos that they took when the train was out there. Bob, if you can put up, I'm going to show you one, because what their argument is, just photo one. What their argument is, Your Honor, this is as I'm sure you've seen before, This is the trestle, this is the train. There's some debris here. This is one of the photos that was taken by the Wayne County Sheriff's Office. They've argued that the pictures that were taken by Mr. Harrison are somehow work product and that we're not entitled to them. They don't cite any law for that. And the interesting thing about that, Your Honor, is that the only law I could find on photos, and it's two of the seminal cases that established the work product doctrine in Georgia, are railroad cases. And guess what they were asking for in those railroad cases? They were asking for photographs. And both of those cases held the photographs. When you send somebody out there as part of their job, which Mr. Harrison said it was part of his job to investigate these, they're not work product. That case, there's a case called Atlantic Coastline Railroad versus Gauze, 116 Georgia App 216, Georgia Appellate 216, 1967. Then there's Atlantic Coastline Railroad versus Doherty, 111 Georgia Appellate 144, 1965. Both of those cases are about statements taken after a railroad incident and photographs. And both of those cases held those are not work product. Even assuming that they are work product, which we do not, there is a substantial need. We can't go out and recreate the scene. We can't go out there and put the train back. We certainly can't go put any of the victims back. These are the one and only time you can get these pictures, and we think we're entitled to all of them. So I'm a little bit surprised that these would be, that there'd be even any question about whether or not there'd be a substantial need. And I just have to make a point about Mr. Harrison, because that's the person who took these photos. Mr. Harrison is their lead investigator on this. And just to sort of add to our argument about substantial need, you're aware, Your Honor, I believe that at some point early in the investigation, we, on behalf of the plaintiffs, on behalf of the Jones family, arranged with Ranier, represented by Mr. Durham, who's here, to go out to the scene and just take pictures with our experts. We asked CSX if we could encroach on the tracks. They said no, we can't. So we said fine, we won't. We go out there to the scene on that day, and Mr. Harrison is there. And Mr. Harrison, once you get a chance to meet him, Your Honor, which I think you will, is a very imposing person who came out there dressed in military sort of garb with combat boots on, a t-shirt. He's a big guy. And Mr. Harrison first tells us, when we first go there, says, you can't get anywhere on the tracks. And we all say, I'm there with my experts. There's other counsel that are there. There's a lot of people there. We say, okay, we won't get on the tracks at all. And he also says, don't get on the gravel. We say, okay, we won't get on the gravel. We don't go anywhere near the gravel, Your Honor. We ask if we can go down the railroad a little bit just to take some pictures, look at something. We do that, still not getting anywhere close to the gravel, about 30 feet away from the tracks. And something gets Mr. Harrison angry at us. And he starts yelling. He sends the CSX police officers running after my experts. And he threatens to arrest them. And he threatens to arrest me. And I say, well, you know, we're doing exactly what you told us to do. Where would you like us to be? And he says, you can't be within 100 feet of the tracks. And I said, you're telling me now that now we have to stay 100 feet away, you're kicking us off this property? He says, that's right. And I said, well, what authority do you have to do that? And he said, and I'm going to quote you what he said. He said, you tell the judge, I work for CSX. I don't work for him. So the one time we tried to get out there and inspect and do some of this work and do some of these photos, and Mr. Harrison, the person who they filed this affidavit on, threatens us with arrest. So I find it a little bit surprising that he's the person that they are relying on for this, and they didn't bring him to court. The other thing is,
maybe I'll do as Mr. Harris did and go in reverse order if the court would like me to address those extraneous and collateral issues that have nothing to do with why we're here.
Let me get this right. I mean, right now we're here about the video and whether it's available and what circumstances and the photographs. So
That's right.
Let's talk about the photographs first.
Okay.
It seems to me that they have a pretty strong argument on photographs, but before I even came here with that sort of, I think there certainly are occasions where maybe photographic evidence can become a work product, especially if you have your experts examining enjoying something and then you videotape or photograph it in connection with, whatever the product may be or the scene may be. But it seems to me that the photographs that are taken relatively or immediately after an event of the scene are the kind of things that, while there may be other photographs taken by other sources, that those can't be readily obtained by some other means, but I think it's more of the standard locality issue. So tell me about that.
Yes, Your Honor. As Mr. Harrison's affidavit explains, he was out there for the purposes of documenting the scene in anticipation of litigation.
Well, I agree with that.
So-
I agree that's what's contended.
So we have a prima facie showing of work product photographs. So the question then is, to what extent is there a substantial need, and to what extent can they get the substantial equivalent without undue hardship? And our position, Your Honor, is because there are these Wayne County Sheriff's Office photographs, there are a bunch of photographs that have been on news articles from various people in the film crew that were taking pictures all over the place, both before and after the incident, that there's a whole universe of other information that we think needs to be evaluated before this work product privilege is invaded. We filed a privilege log, so we think plaintiff's motion is premature at best on the photographs that Mr. Harrison took that are work product.
Well, they probably need it before they propose them, though, right?
Well, Your Honor, if we're going to use the photographs, we certainly will give them to them. We're not trying to hide the photographs.
Only eventually they're going to, I don't want to get into the
Yeah.
deposition issue, and it's not before me, but eventually he's going to get deposed, I
Yeah.
assume, right? I mean,
And, Your Honor, and just, I'll address that very quickly. Mr. Lowry did request Mr. Harrison's deposition, but there were 20 lawyers to coordinate, and he never made any attempt to do that. So to suggest that we haven't.
I think we dealt with like the issue before about getting on the track and the investigator. I think we had some discussion about that previously. And that's, I'm not saying it's not an important issue for everybody, but right now, my real interest is photographs and video. At some point, he's going to be deposed in the normal course of the case, and they're obviously going to be entitled to a question about this kind of issue. So, all right, well, let's talk about the video a little bit. The affidavit from Mr. Harrison says that as LDVR data is automatically overwritten every 72 hours, the February 20, 2014 LDVR data for train Q03220 was not able to be preserved.
Yes.
So, and at this point, I mean, it seems to me we're sort of arguing, and the plaintiffs are sort of arguing some spoliation type issues, but there's nothing pending for me to consider on a spoliation type matter at this point in time. And I guess in that connection, there might very well, in fact, be some issues as to how this video became unavailable. But what's the current status of the available video for train Q03220?
Your Honor, the LDVR for that video, and Mr. Jordan represented the court that this information is stored on a hard drive. That's lawyer speak. I will say we don't know for sure exactly how that medium is transferred, so I don't want there to be any misperception about that. We can certainly find out, but...
Well, let me ask you this one thing, because I don't say it before I forget it. I'm getting all start forgetting things. The license is a GE product. I guess the software is